My friend Andy McCarthy just dropped, I'm going to use the words of the kids these days, the parlance of the times, a straight fire column on all of this, where he dives into a couple of different cases that are actually being used by Hunter Biden's defense because they're insanely trying to argue that he was a drug user, so you can't really be shocked that he was going to lie about using drugs on a federal forum. And you guys are very familiar with our good friend Andy McCarthy, best-selling author. He is his book, Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. And he's also a contributing editor at National Review. You see him on Fox News, and former chief assistant U.S. attorney. He joins us now via Skype. Andy, always a pleasure to have you. This column, I love the way that you break things down, by the way, because you always give a master class in this. You think that Hunter Biden's defense is not going to be successful because he's actually trying to use arguments that are really in favor of the Second Amendment to kind of free himself of this mess. Just as the trial has gotten underway, what has been your initial reaction?
Well, thanks so much, Dana. And yeah, I think he's trying to tee up his appeal because he knows what the evidence is coming in, and he knows what Judge Noreika is going to instruct the jury at the end. Basically, they litigated the Second Amendment issue pre-trial. He tried to use the Bruin case in order to argue that the federal statute was on its face unconstitutional. And the statute I'm talking about here is 922G3, the provision that makes it a crime for a user or addict of drugs to possess a firearm. So he lost on that issue, and then he tried to argue that they should instruct the jury that unless he was using drugs the moment that he made the purchase, that basically he should be acquitted. And what the judge decided was she's going to instruct the jury that the government has to prove beyond a reasonable doubt that he was a drug user or addict around the time of the purchase. And I think what this gets down to is after Bruin, the court made it very clear that we're going to interpret the Second Amendment right in accordance with what the original understanding of the amendment was at the time the Constitution was adopted in 1791, and at the time that the Second Amendment and the other Bill of Rights provisions were applied to the states by the 14th Amendment in 1868. But you have to show that there was an original understanding of what the right to keep and bear arms was, and that regulations are consistent with American traditions in that regard. So the issue comes down to, what do you think drug use is like? Do you think it's like alcohol abuse? In which case, the traditions of the country, look, this is a hard drinking country, right? Mm-hmm. The tradition of the country is if you were intoxicated, they could take your guns away, but then they had to give them back to you, right? Or if you went into the saloon, maybe the bartender would take the gun, but you would get it back as you left, right?
Yeah.
If that's what it is, and that's what Hunter's trying to analogize his behavior to, then he's got very broad rights. On the other hand, if drug abuse, and particularly drug addiction, is like mental illness, then there's a long tradition in the United States that goes back to the founding that people who were declared to be insane, if they were adjudicated to be like non compos mentis, you could take a lot of rights away from them, including their right to liberty, but also their gun rights. So I think he knows he's lost in the trial court. He's hoping as a Biden in Wilmington, maybe the jury will acquit him anyway, because they're very influential in that small pond there. But his main thing is he's trying to tee up, I think, for if he gets convicted here, for his ultimate appeal.
Yeah. Andy's column, it's called Hunter Biden is Playing the Long Game. And it is. I know you mentioned that they had kind of litigated that before, or pre-trial, the Second Amendment issue, because didn't his attorneys bring up Cantor v. Barr? And that was the case where it was a nonviolent, it was a guy who was convicted of a nonviolent felony, and he was arguing that that did not, he should not be, have his Second Amendment rights removed as a result of this because they're natural rights, therefore they couldn't be abridged. And it was something that Amy Coney Barrett actually had agreed with. And it was wild to see Hunter Biden's attorneys cite that.
Yeah, well, it's amazing for two reasons. One is Joe Biden's a lifelong demagogue on this issue. He's one
Yeah.
of the worst offenders. And yet Hunter's defense here is the Second Amendment. And the second thing I would point out, for all this nonsense that Hunter has said about how, he's the one being singled out.
Mm-hmm.
If he was not named Biden, this offense happened in October of 2018. He would have been indicted by the end of 2018 or early 2019, and this case would be over. But because Weiss didn't indict, because he dragged his feet on this, just like he dragged his feet on everything else, the case still wasn't adjudicated when Bruin got decided 4 years after Hunter bought the gun. So now he has a defense that's available to him because they delayed in charging him that wouldn't be available to the normal person.
That's amazing. That is actually amazing. Talking with our friend Dana McCarthy. Yeah, so he actually made it a little bit easier for him. That's kind of unbelievable. You said something interesting because it's in Delaware. I mean that's you do have to factor that into the jury pool. I mean, they can break it down to how many are gun owners and how many are this or that. But I mean, Biden's are big deals. They're still a big deal in Delaware.
Yeah, it's not just a smaller place. I remember when I grew up in the Bronx in New York, and Stanley Friedman was the Bronx borough president. And I always thought when I was a young prosecutor, the craziest move I ever heard, we indicted Stanley Friedman in the Southern District of New York in the famous, back then, kids, this is ancient history, but the Parking Violations Bureau case. And I always thought it was crazy that Friedman moved to get the trial out of the Southern District, and he ended up being tried in like New Haven, Connecticut. And I was always thinking, a Jewish leader who was very well known in the Bronx, and who, like, if you assembled any group of 100 people, you'd get a bunch of people who like knew Stanley Friedman or owed a job to Stanley Friedman. And I just thought it was nuts that he moved the case out of the Bronx. And here, obviously Hunter, this is a home game for Hunter. I mean, I think he's going to get convicted. The evidence against him is overwhelming, but this is not Donald Trump in Manhattan.
Yeah.
This is definitely a home game for Hunter.
We're talking with our friend Dana McCarthy. You mentioned former President Trump and the verdict that came out of Manhattan. There's a lot of people saying, because I know that they're going to go through the appeals process, and this is going to be a long process. But so far I hear everyone saying that, well, the appeals court, have you looked at the judges? Have you looked at this? It's not going to happen. But I think it could, though, because it's such an egregious, it's just wild to take what is essentially an expired misdemeanor and try to tie it to like this mystery felony, so that you can get beyond, the statute of limitations in state court and then try to litigate it in the federal arena. I mean, it hasn't been tested. So I think that would kind of weigh in Trump's favor, would it not?
Yeah, it would, especially because in the end, the mystery crime was itself a misdemeanor. Yeah. What they ended up saying was the crime that Trump was hiding was this misdemeanor conspiracy statute in New York, an election statute, which makes it a crime for two or more people to agree to influence an election by unlawful means. And the unlawful means, of course, are the federal campaign finance laws that Bragg doesn't have any authority to enforce. So I think, interestingly, the mystery crime with being that it's a misdemeanor, it too had a 2-year statute of limitations. So Bragg's theory here is if you smush two time-barred misdemeanors where the time to prosecute actually lapsed in 2019, but he could put them together and somehow you have a felony that has now a 6-year statute of limitations that he can bring in 2023. And then the crime under the crime is a federal crime that he doesn't have jurisdiction over.
Wow.
And I haven't even begun to scratch the surface of everything else that's wrong with the case. So I think you're right that Trump will get a better quality of justice in the appellate courts. Remember, they just overturned Harvey Weinstein's conviction in New York because it was an unfair trial. Now, it took 3 years, but they did it. And in this instance, I think the New York courts are also going to know that their work is going to be checked by the appellate courts. This is not going to end at,
Yeah.
the New York Court of Appeals. It's gonna be reviewed by federal courts if there's still a conviction standing.
And that's a really good point. You mentioned, it took 3 years for the Weinstein because it was so prejudicial to stuff that they were very similar to what
Yep.
was being introduced in Trump's case with Stormy Daniels going on and on the witness stand and that. I know he had said something about trying to expedite this and just going right to the Supreme Court, which I know you can't do. You have to go through the process. But what is realistically the timeline here? I mean, is it going to be as long as a Weinstein thing?
Yeah, it could be. It could be longer if there's if his conviction gets upheld in the New York appellate courts and it lands in federal court, that'll
Wow.
add another layer to it. But on your point about like people trying to leapfrog
Hmm.
into federal court here, one of the things I think people are missing, which is an important piece of history that we have to remember here, inconvenient history for the Trump side, but history nonetheless, is that remember, Trump tried to move this case into federal court shortly after he was indicted, and it ended up in the Southern District of New York. And a senior federal judge, Alvin Hellerstein, who was a Clinton appointee, uh, basically sided completely with Bragg and greenlighted pretty much what Bragg wanted to do, which I think is a big part of the reason that Merchan, the judge in the New York case, was so confident they could get away with things like enforcing federal law. So for those people who say we got to get this case into federal court, it's already been in federal court. It wasn't a very good federal court decision, but it was there already. And I think that's more reason that the federal courts are going to say this has to play its way through the state court before we're going to look at it again.
Yeah, we have to follow that process. Andy McCarthy, his book, Ball of Collusion, The Plot to Rig an Election, Destroy Presidency. You're going to have to write another book now. You're going to have to include all this stuff in it.
Oh, yeah.
You're like, you sound so excited. Have another bestseller on your hands. Then you have
Oh,
to
yeah.
go
Well,
a week
if
of
I could
promo
get
for
someone
that.
to write it for me.
I know you've been busy. I've been seeing you everywhere. Our good friend Andy McCarthy, always a pleasure, Andy. Thank you so much for sharing your expertise with us.
Thanks, Dana.
Of course.